Hello and welcome. My name is Father William Maestri, and this is Overfed and Undernourished. Today is Tuesday, June the 30th, 2020, and the United States Supreme Court issued a very important civil rights ruling today in the field of education and civil rights. To be specific, it was a case that was entitled Espinoza versus the Montana Department of Revenue. And to give a little historical context, back in 2015, the Montana legislature established what it called a tax credit system in which individual taxpayers could contribute $150 to a fund specifically designated for scholarships for children who would be eligible to go to any particular school they wanted to, their choice, on the basis of they and their parents. And the barrier was the barrier of money, because private education, religious as well as secular private schools, obviously operate by tuition. And many children who found themselves either in schools that did not meet their needs or schools that really did not meet the state even educational requirements overall, children were very often trapped in those particular underperforming schools. And so this particular program was designed to allow children, all children, to apply for admission to those schools that would accept scholarship children from this particular public fund. Now, naturally, you know what follows. Immediately, people went to court, various groups who have long opposed this, from teachers' unions to cafeteria workers to public school transportation drivers, various lobbying groups, and so on and so forth like that. You're familiar with the usual suspects. They were opposed to this because they held that it was aid to religious schools as well, and therefore this was unconstitutional because it was really the establishment of religion and the state supporting of religion in public schools. The state Supreme Court took the case, the state Supreme Court in Montana took the case, and they ruled that indeed it was unconstitutional and that this particular program should cease, and therefore those who donated the $150 would no longer be entitled to the $150 tax credit, dollar for dollar, provided by the state. Well, a litigant, Mrs. Espinoza, she wanted her child to participate in this particular program so that the child could attend a private school. And so she filed suit in federal court, and the United States Supreme Court heard the case, and today by a 5-4 decision, today being Tuesday, June 30th, ruled that indeed reversed the Montana State Supreme Court, and by a 5-4 decision, the decision being written by Justice Roberts, who has come under some fire recently for those who have a more conservative, or we might say a strict construction view of the Constitution. He wrote for the majority. And once again, of course, on these kinds of issues, the court was badly divided, 5-4. And in his opinion, Chief Justice Roberts indicated that this was indeed an illegitimate discrimination and exclusion of religious schools simply by the fact that they were religious, and that this was not an establishment of any particular religion, but that it was simply enabling parents who, in the best interest of their child, educationally as they determined, would have the means to enter private schools, religious as well as secular private schools that would be willing to take such children into their school and have them enrolled for their educational benefits as parents saw fit. And the parents, we like to believe, and we do believe, are the primary educators of their children and should be the authority in how their children are educated so that they can have their chances and to participate in American society. The stumbling point in the case was an amendment that is called the Blaine Amendment. The Blaine Amendment was put forward by a United States congressman back toward the end of the 19th century, James Blaine. He was a congressman. And James Blaine, he was fiercely anti-Catholic, made no efforts to hide his bigotry and his downright disdain for Catholics and basically all things religious. In addition, he was very much opposed to immigration into the United States. And of course, toward the end of the 19th century and into the early part of the 20th century, the great migrations were coming from various parts of Europe and other parts of the world into the United States. And many of them, a significant number of them, were not only immigrants, but they were also Catholic, or at least had some religious affiliation, and it may be Protestant affiliation as well. But Blaine found this a great threat to a kind of Protestant America as well as a kind of nativist approach, because the nativists were very strong, along with the Know Nothing Party that developed in the 20s, and also the Ku Klux Klan, which was highly anti-Catholic. And so the Blaine Amendment was put forth by Congressman Blaine as an attempt to say that no tax money could ever be used for religious schools in the promotion of education or the carrying out of the function of education. And that particular amendment failed by several votes in the United States Senate. However, those who favored restriction of funds such that religious schools would never receive any public monies or any public support, along with those who opposed immigration. The states, however, were free in their particular constitution to insert the Blaine Amendment into their constitution, and over 40 states did at that particular time into the 20th century, and even today there are states that in their constitution that have the Blaine Amendment, one of which is Montana. Chief Justice Roberts indicated that this was out-and-out discrimination solely on the basis of religion. And the Montana Supreme Court, the state Supreme Court, never really explained how allowing all children of all religious persuasions, or no religion at all, to apply for these particular funds. In other words, it wasn't restricted to Catholics or to Episcopalians or Presbyterians, what have you. It was open to all. So in that sense, it was universal, it was non-discriminatory. But the Blaine Amendment is highly discriminatory against religious institutions of any persuasion having access to and being supported by taxpayer money. And the court ruled today that indeed this was unconstitutional and a violation of the free exercise, and also a violation of equal access and equal treatment simply on the basis of religion. And it is kind of baffling in a way that once again on an issue like this, which is really an issue of civil rights, the court was divided 5-4 because this is a civil rights issue. It is an issue of unjust discrimination on the basis of religion, especially for those parents who want for their children a better future, better educational opportunities so that they can equally participate and use their talents and abilities, their efforts, their skills that they've acquired to participate fully in the American way of life, and to have a better life for themselves, and also to take care of their children and perhaps even their parents or those in need. So this is really an important access equally. This is really an equality issue as well as a fundamental civil rights issue, and in many ways a human rights issue. The right to access to education by an open and free society. We have to be honest, there is a color barrier in American society, and I guess in all capitalist societies, to education. But the color barrier is not black, white, brown, yellow, or red. Often the barrier is green. It's the color green. It's an economic barrier. Many hardworking parents are taking 2, sometimes even 3 jobs to place their children in what they believe to be the proper educational environment for their children to go on further and to succeed with their God-given talents, and also with the skills and their own willingness to work and to study and to sacrifice in order to achieve a better future for themselves. And this is an important step forward because it opens up education. It opens up education. And it's a tremendous victory for children and for families, and also for American society overall. If we really believe that education is a key component, not the only component, the importance of family, environment, the individual characteristics of the child and all of that, but overall education, along with the environment within the family, is a key component to a child's educational success. And economics should not be a barrier to allowing many, many gifted children, many, many talented children to participate fully in the educational opportunities that this country offers. Also, it is somewhat troubling, having worked in the field of access to all educational opportunities, that we find at times that there are religious groups who are opposed to access, opposed to opening up their particular schools. They believe that certain classes or groups of people that come in, perhaps from underperforming schools, will dilute the educational quality. But certainly for people of faith, I think that we have a responsibility, as well as a tremendous opportunity and calling from our Christian or Jewish or whatever religious belief, to as a people, as human beings, as a nation, to open this access so that these children and their families can really be served. And in the long run, it serves the quality of life of American society itself. We have many jobs, for example, that go in America that go unfulfilled. And so we are importing those kind of skilled workers into our country. We have to take care of the quality of education of all people in our particular society. And so this is indeed a civil rights issue. And so today, I think, is a tremendous victory for education. It's a tremendous victory for families and for children. It's a tremendous victory for our society. And it says once again that we are open, that we're an open society, we value equality, and we want to provide that opportunity, not the results, not the outcomes, but we want to provide the opportunity for all children to participate to the full extent that they can in the great American story of opportunity, especially through education.